Very much. All right, we have two different matters here this morning for presentation. This is the presentation docket for Patricia Fassett. So good morning, everyone. I'm going to start with the Wishard and Wishard matter. Good morning.
Morning.
I received the proposed parenting plan. I also received the objections to the order. I've worked my way through some of those and made changes based on my ruling. So I'll walk through that. And then there's some that I want to discuss with everyone. So let's just start page 1, section 3A1. I am reserving that. So I've lined out neither parent and just indicated reserved and initialed that. Page 2, 4B1. The line 19, I indicated 18 and 19, I should say, non-professional supervision shall occur at, and I just lined out the father's home and so it shall occur at such location as agreed upon by the father and supervisor. And I initialed that. And line 23, I just included Jonathan Wishard's work schedule and the supervisor's schedule, initialed that. So B2 changed from 8 hours prior to 24 hours prior. I think that's reasonable. There's if we're potentially dealing with an addiction situation, I think there needs to be some flexibility there. 24 hours to me seems appropriate. And then section 3.
So we need to decide if we're going to, were you able to determine if we're moving our review hearing to Monday, July 10 at 11:30?
We can do July 10th at 11 o'clock if that works for everybody. So I was able to confirm we can special set at that time. So
I'm available.
Okay.
I'm available. That's fine.
All right.
And I feel available.
Okay.
So could you just interlineate that then at that open line on 3?
Yes. And what I did on line 3 is I changed visitation for Jonathan Wishard may be reviewed instead of will be reviewed, may be reviewed. And what date did I say? July 10 at 11 o'clock. The only thing that I will just throw out there as a preface is I don't know if I'll have to be at the jail at 9 a.m. on Monday. And then if that special set will be here and how long that hearing will be. So just if I'm not here right away, I'll try to get somebody to let you all know, but as close to 11 o'clock as possible, we'll start that.
Is that for your sentencing?
Yeah, I have a 9 o'clock sentencing. I'm not sure if it's going to be at the jail or at the hall. So okay. If it's at the jail, then I'll likely have to come back over here for the presentation. So there's maybe a little bit of a delay, but I'm going to set it for 11 o'clock a.m. July 10th, 2023. The expectation is that the visitation will move to unsupervised. I struck that. We don't know what the expectation is. So I'm obviously willing to consider anything, but I don't like the definitive language that's listed there. What happens if the petitioner tests positive and his levels increase as written? It would require motion, docket notice, and orders shortening time, significant fees. Ms. McLean, you have any response to that?
So I had simply just provided that it would be a docket notice, that it could be put on the next available docket on just a docket notice. We wouldn't have to file a formal motion or an order shortening time so that the court could immediately address that. And then if you wanted to have more information from the parties in writing, you could make that determination at that time.
I'm okay if it's very clear that that's all that's required and it's on the next available docket. Because again, this order just limps us through really for the next month. And so that's fine so long as that language is clear.
So if you look at line 2 on page 3 of my proposed order, it said failure shall be considered a positive test and all visitation shall be reviewed by the court at the next available docket for all parties on filing service of a docket notice.
And I would just add that no motion required.
I'm fine with that.
All right, I'll put a little asterisks in there and indicate that no motion is required in that instance.
Thank you.
Ms. Baldwin's suggesting that just healthcare is listed at this point in time. Do you have any response to that, Ms. McLean?
Well, I think that parents should be allowed to be involved in those decision-making areas that have been listed.
Inherently, the problem is that we've reserved domestic violence. If the court makes a domestic violence finding, that sparks very specific things as to joint decision making. In this case, the child is 3, they're not entering the military, they're not going to school, they're not really doing any activities. I think that we should just sort of be more succinct here and limit it to the things that are rationally going to happen in the next month.
And yet you see multiple text message communications between the parties. I think that that needs to be encouraged. I think moving forward, the expectation is that both parents are going to be healthy and remain involved with this child. And the earlier that we can establish those requirements as far as being separated and maintaining that communication, the better. I mean, that's one of the reasons why the court required the parties to participate in the parenting seminar.
I don't disagree. I'm gonna strike the driver's license, piercing, tattoos, and military and underage marriage. I think we're well beyond any time frame, or we should resolve this well beyond any time frame where those will factor in. But I'll leave extracurriculars, religious decisions, healthcare, and any estate decisions as joint.
All right, thank you.
And so summer and holiday schedules. So Ms. Baldwin.
So same, I'm just asking that we reserve it. Again, this is an order that really limps us through. And so for about a month. And so it makes more sense to reserve these than it does to sort of say, to sort of try to pin something else in. We're really on an interim order, not a true temporary order. So again, that's why I would reserve these.
And I'm not pinning anything else in, but my concern is the potential argument that, well, the summer schedule is reserved. Summer, if we're looking at a school schedule, starts next week for kids, which means potentially it could be interpreted that the visitation schedule doesn't apply because it's been reserved. So therefore, there could be an argument that my client isn't entitled to visitation. What this language does is it says you follow the school schedule. It's the same as the school schedule. The school schedule says you follow the paragraph 4B as far as his supervised visitation. So I think it is appropriate and will continue for that continuity of visitation for my client as is outlined in paragraph 4B.
And no one here is going to make that argument because this is an interim order. The court's very clear about what the visitation schedule is. So I think given the practitioners involved, that argument falls flat.
And I guess, again, my concern is I don't know how long Ms. Baldwin's going to be involved in this case. I don't know how long I'm going to be involved in this case. We don't know if we're going to be in front of Your Honor consistently throughout this case. So there's a lot of unknowns. I just want to provide consistency for any judicial officer who's going to be reviewing this.
I'm going to leave the language in. I frankly, I don't think it being there or not being there is too much of a difference, but I'm fine just leaving that. So I'll leave 9 and 10 as proposed. Then it looks like the last section is same page 5, section 12. So what I've done, and then I guess Ms. Baldwin, I'll ask if this resolves your concern under A. It says Kylie Wishard, and I included or her designee shall deliver the child to supervised visitation location, and Jonathan Wishard shall transport himself to and from any supervised visitation location.
I think that's fine, given the change that you made back on the other section.
All right. Any other areas of concern or?
No, thank you. We'll circulate a conformed copy to all parties once it hits Odyssey.
All right. And Ms. Baldwin, are you okay with me indicating approved via Zoom?
Yes, that's fine. Thank you.
Thank you. And Miss Kale, thank you for being here. It's my first time seeing you, Patricia Fassett. Nice to see you.
Meet you, Your Honor. Thank you.
All right, so we will see you all
right,
Monday,
we
the
can
10th
move
at 11
to-
o'clock.
Thank you very much.
Thank you.
Good luck,
Our
everyone.
second matter on this morning, Miller versus Amaskita. Good morning,
Morning, Your Honor.
Mr. Miller and Miss Amaskita. Can you hear me okay?
Yeah.
Perfect, good. And Mr. Miller, I just want to make sure, I know your attorney's here, but want you to make sure you can hear me as well.
Yeah, I can hear you now.
Okay, perfect. Thank you. Okay, so I reviewed a lot of what's going on, and I'm going to reiterate a little bit what I said before. I feel it's a little unfortunate that I'm glad that we got to a trial because that's a hopeful resolution, but there were a lot of steps that frankly kind of got looked over in your case. So I'm working backwards, and I kind of told you guys that a little bit at the beginning. So I'm going to enter an interim ruling, which includes the visitation that I'm going to have in here. So I don't know, and I don't necessarily need an update on the status of the protection orders because I think I've taken that into consideration in this ruling. So what I'm indicating is that both parties shall attend Love and Logic parenting classes and provide proof of attendance to the court as soon as possible. That communication between the parties is authorized and shall be done through our Family Wishard parenting application. And this should be the method of communication for the parties regardless of the status of the protection orders. So I'm authorizing that communication between the two of you. That's an application that you can put on your phone that essentially keeps track of everything. You can share calendars. And frankly, if one side does something to the other side through that app, it'll record it. And that'll be something that, to help each other be mindful of how you're communicating with one another. As previously stated, I'm ordering both parties to undergo a domestic violence evaluation by a Washington certified provider and provide the results to the court within 5 days of receipt of that evaluation. In the interim, Miss Amaskita shall have supervised visitation with the child. I gave this a lot of thought. I still have some concerns, frankly, about the circumstances surrounding Mr. Chaddock and some of his behaviors towards the child in question here, and behavior towards some of the other family members. So, and I reviewed again some of the testimony, and I have to note that, I'm sorry, Ms. Sager, her testimony was very, in my opinion, neutral and involved in the best interest of the child. Clearly, she has a long-term relationship, obviously, with her son, but also with Miss Amaskita. So here's what I'm suggesting. My suggestion is that she seemed willing to be a supervisor, and I would like the respondent to consider her being a supervisor for visitation. There is a visitation supervision rules form, Ms. Holder, that we have here in Cowlitz County, and it's basically just a 2-page thing saying that, my obligation is to the child in the best interest of the child. If I see anything from either party that concerns me, that I'll let the court know. It's pretty generic, and that they're willing to supervise. So if Ms. Amaskita is willing to allow her to supervise, I would like her to receive up to 8 hours of visitation a week. That can be broken up into multiple visits to accommodate the schedule of the parties, or however, I'm not going to, given everybody's different work schedules and other children, I'd ideally like to leave that to the parties to try to work out. If Miss Amaskita chooses to refuse that as visitation in the interim, then I'm authorizing up to 4 hours a week of professionally supervised visitation. The visitation shall occur with just Miss Amaskita. Mr. Chaddock should not be part of any visitation at this time. And as I stated, if Miss Amaskita chooses not to utilize the non-professional supervisor for visitation, then she's authorized up to 4 hours a week for professionally supervised visitation. And that party shall communicate through the professional supervisor to coordinate those visits. I'm going to set this case for review on August 8th, 2023 at 1 p.m. for compliance with the above orders. So you may or may not be able to get those evaluations done by then. My hope is that you will. If you are able to get those evaluations done prior to that, I'm more than happy to review it sooner. So if you're able to communicate with one another through that Our Family Wizarding app, and you both get your evaluations done within a month, it's noted on the docket, and I'll review it as soon as you note it up. But I wanted to put a date out there so it doesn't just kind of slip through the cracks. Mr. Miller shall remain the primary parent in the interim and have all non-emergent healthcare authority for the child, as well as the decision-making authority for the child for school until a final parenting plan is entered, which hopefully will be in August. Neither parent shall inquire of the child their requests or concerns about visitation, or inquire about or speak disparagingly about the other parent during their time with the child, and no discussion of the parenting plan with the child at all, other than to inform the child when scheduled visitation is happening. So this will be based on the protection orders. And like I said, I don't know the status of that. I understand that you were going to be revisiting that. This will, because of the language that was included in those, this will supersede. So you will be allowed, Ms. Amaskita, to see your child, even if that protection order is still in place. It just will be supervised at this time, either professionally or unprofessionally, whichever you choose. Any questions about any of that at this point?
Your Honor, I have 2 points I'd like to bring up.
Sure.
First of all, Mr. Miller has already begun taking his parenting classes, but it was not through Love and Logic. We provided him with another one, which is Children in Between.
Okay.
If that would be okay with the court.
I'll interlineate that Love and Logic or Children in Between. Okay. I don't know, Ms. Amaskita, have you started a parenting class yet?
Yeah, we both started Love and Logic, and we have our assessment RA set.
Perfect. And since you started Love and Logic, Ms. Amaskita, do you know how long that class is?
6 hour. It's a 6-hour course over a period of time.
Okay.
With 6 different modules.
Perfect. Okay. So I'll include in there, Ms. Holder, Love and Logic or Children in Between. If Mr. Miller wants to take Love and Logic as well, great. But I definitely want a parenting class. All right, Ms. Holder, what was your other issue?
My second issue is I would like the court to be aware that this was mostly pro se up until a few weeks ago, and I think you can note that from my notice of appearance. And because Ms. Amaskita is pro se, I just would like the court and Ms. Amaskita to know that if she feels Mr. Miller or there's a breakdown of communication or something is going on, feel free. She can contact me, and I will treat her with the utmost respect, and I will have conversations with her like she is another attorney, but I will break it down in more simple terms for someone who is not an attorney. So I just want Ms. Amaskita and the court to know that I am willing to work with her and trying to negotiate. And if something is not clear, she doesn't understand something, while I cannot give her legal advice, I am more than willing to work with her.
So, and I appreciate that, Ms. Holder. So what essentially that means, Ms. Amaskita, is if you want to find out if Mr. Miller is ready to note this on a docket sooner or something along those lines, you can call her office and say, hey, look, we got all of our stuff done. How is Michael close? Can we get this on before? or if any other questions about that, if you have a question about, I'm sure Ms. Holder is also familiar with our family wizard, and if, you know, to make sure that you two can connect on that app, it sounds like she'd be willing to help with that as well. I would like the visitations to start as soon as possible. Miss Amaskita hasn't seen her child since February, I think. So as soon as the parties are able to work together and get visitations started, either through Miss Sager or through professional supervision, a location, that might take a little longer to get set up, but hopefully everybody will work together to get that started as soon as possible.
Your Honor, may I ask Ms. Amaskita if she would be willing to use Ms. Sager, or if she needs some more time to think about it?
I'll use her because the places are fully booked.
Okay. Thank you.
All right. As I stated, I'm more than happy to review this before that August 8th date at 1 p.m. So if you want to note it on sooner, I'm more than happy to. And then obviously, Ms. Amaskita, I understand you and Mr. Chaddock are pursuing options as far as those restraining orders go. This, as far as the order with you and the child and you and Mr. Miller, this will supersede that as long as you follow the order with the parenting app and the supervised visitation. All right.
Okay.
All right. I look forward to getting the information back from you all. You can submit anything as soon as you get it if you want, and to ensure that I've reviewed it before that August 8th date. If you both mutually decide that, hey, we're not going to have our stuff back by that date, if it's taking a little longer and you want to strike that and reset it, and you're willing to work together on that, that's fine as well.
Okay.
All right. Hopefully those first visitations get started very soon, and I wish you guys all the best of luck, and we'll see you August 8th at 1 p.m.
Thank you, Your Honor.
All right. Thank you.